Another area to keep in mind and stay on top of is timekeeping essentials for California compliance. Have a timekeeping policy, establish and regularly communicate a timekeeping policy to the employees. The policy should set forth that the employees always have an open door policy and an open door where they can complain to their supervisors or managers or even human resource about any missed meal or rest breaks or any unpaid overtime, off the clock work that they may have done. If employees routinely acknowledge that they understand the timekeeping policy and are agreeing to record the time, although through the employer's system, this can go a long way in defeating any claims for off the clock work. Also, including the policy that the employee agrees to review their wage statements and immediately and promptly report any errors that they find on their wage statements. Have a practice of documenting employees who often violate the timekeeping policy or don't follow it. This also goes a long way where you may end up having a claim for unpaid wages from an employee, and you can note that the alleged non-payment claim might be meritless. Another area to keep in mind is rounding of time. You want to review the timekeeping system or the payroll company system to make sure to see if the employee's time is being rounded, and if they are rounded, is the policy in compliant with the law. Rounding is legal under California law if the policy rounds up and down from the midpoint of every 6 minutes. Policy must be applied in a way that on average does not favor underpayment. Policy, for example, that only ever rounds down and never up would likely be unlawful. If you have a rounding policy, you want to ask, is rounding policy necessary, or is it easier to pay the exact amount the employee clocks in and clocks out? And employers should probably want to eliminate rounding practices altogether. Again, while it's still allowed for purposes of calculating wages, but the day may be coming when courts are probably less likely to tolerate rounding of wage calculations, even when the policy is neutral and it doesn't disadvantage the employees. This is because computerized timekeeping systems make it easier to precisely record time. And California Supreme Court has already noted in a case they decided a couple of years ago that technological advances may help employers to track time more precisely, and employers are in a better position than employees to devise alternatives to rounding time clock punches. Employers want to make sure that employees are paid for all time worked. Review the time records and the wage records of your employees. Probably want to do periodic audits to make sure that employees are being compensated accurately for all of their time that's being that they work. The de minimis doctrine may permit employers a defense for claims by employees that they were not compensated for very small amounts of time that were difficult to track. While this defense may be available to California employers, employers should not rely on the defense when it is known the employee is working time that was not compensated. For example, employer is aware that the employee is performing off-the-clock work, or there is some task that the employer requires the employee to do before they're able to clock in. The employer must pay the employee for that time. Another big key item to remember going into next year is employers should do everything they can to ensure that they can prove meal period compliance. It's not enough to just have a policy that says that company provides meal period before the 5th hour. It's the employer's obligation to keep accurate records. Employers are required to record when the employees take their meal breaks, and also to keep a record of all the time records for the employees under California wage orders and the Labor Code section 1174.